All right, we're back, and I'm going to talk about the assignment that I mentioned during the last video. So you have this jury nullification we talked about. That is, in essence, what your assignment will be. You need to find a court case that serves a good example of what you believe is jury nullification. Tell me, in essence, what class or what case you selected. Um, Give me some details to it. Think about it as a case brief and summarize what actually happened in the case, who was involved, what the crime was. Give me a little background is all I'm asking for. Okay? And then explain why you believe it was a situation of jury nullification. So if you explain the case well enough, besides telling me, kind of the account of what happened, you can also give me information about what evidence was available, uh, what defense was used, things like that that will help me understand exactly why you believe it was jury nullification, and ultimately, do you agree or disagree with the jury's decision? Yes, it was a case of jury nullification, but do you agree with that verdict, even though it may not have been supported by evidence? So just like I said, give me your thoughts on that. Some of this stuff is not opinions. This is just facts up here. Your opinion does not come until down here at the bottom, but with your opinion, you need to have some good reasoning and facts that would back it up. So this will be due next Saturday. So not this coming Saturday, but this Saturday following that. I will have a journal available for you to submit that. So it probably won't be up. The journal won't be up maybe until say next week, maybe this weekend, but more than likely next week. All right. So next thing I want to talk about is the court system. This is how we organize it. As you can read here, I mentioned this before when we're talking about judges, bench trials and things like that. There is the lowest level of courts, which are actually not true trial courts. They're considered courts of limited jurisdiction. And so these are the state level. There are no courts of limited jurisdiction on the federal level. We'll get to that in a little bit. But as far as for state level, start off with courts of limited jurisdiction. Like you can see there, minor offenses, infractions. You can have, sometimes you'll hear if you're working law enforcement, DUI court or drug court or things like that. That's what we're talking about with courts of limited jurisdiction. Those are the specific types. So it's usually one judge that hears them, and they are typically heard on one particular day or maybe even two of a given week. That's how a lot of jurisdictions do it. All right, so the next court beyond that is, as you can read here, the courts of general jurisdiction, also called superior court. And these are the original trial courts for most other, say felony charges where you did actually qualify for and get, if you want to call it that, choose to go ahead and go forward with a jury trial. So courts of general jurisdiction are, like you said, any other typically felonious crimes, and this is your first level of trial that we have. Okay, and then later on we'll talk about the more specifics to appellate courts. But I just want you to be aware of what happens after you have your original verdict from the trial court. If either side, typically losing side, obviously, will appeal that to a higher court. Right? They can say, well, I don't agree with that for given reasons. And typically those reasons have to be, I don't want to get too far ahead of ourselves, but typically have to be involved with given rights, whether it be constitutional violations, maybe poor representation by an attorney, not just, hey, I didn't win, so I'm going to appeal. You had to have grounds upon which to appeal. Okay? So, like I said, that's the intermediate appellate courts, and if so, trial court and then appellate court simply means, okay, beyond that, we're going to appeal to a higher court. All right, so now we're at intermediate appellate court at the state level. Okay, well, I don't agree. Once again, maybe maybe that judge or judges in this case, those judges will agree with the lower court's decision, the trial court's decision. Okay, and I want to appeal to an even higher court. So the next thing I go up to is that state Supreme Court. That's the highest level you're going to have for any state charges. So you guys understand there's a difference between a state statute and a federal law, and who you're charged by. So that determines what court system you get put into. But if you are, if it's in most cases, are going to be at the state level. So the highest level you can go to in that state for state statutes and state offenses would be your state Supreme Court. They hear it, and most of the time, if it gets to them and there's a decision made, and we already, we'll talk about, whether they can reverse, vacate decisions, things like that. But a decision is typically made and it ends there. However, occasionally there may be a case that starts at the state level that deals with constitutional rights. If you and your attorneys can prove or indicate that there was some type of constitution or amendment that was that is involved, in essence, part of your rights, not just legality of whether it was right or wrong, but were your rights violated, or things along those lines, right? Only then do you have the state Supreme Court here appeal to the U.S. Supreme Court. Okay, that's the only way state trials will get to federals, to the state Supreme Court, appealing to them, and doesn't happen that often. Like I said, I already mentioned what it has to be, so I don't want to beat a dead horse again. Now, so that takes care of state. Federal level, you would have this district court. So if you are charged with a federal offense, it will start off with the district courts. Their district courts are the lowest level courts they have. Okay, those district courts then appeal to. So once again, similar to what happens with courts of general jurisdiction, those are trial courts, and then so district courts and then courts of general jurisdiction are both trial courts. If you appeal from the verdicts there's an appeal made. At the federal level, you go up to this U.S. the U.S. Court of Appeals, right? And there are 13 different places, and that does matter. You wouldn't think it would matter, but it actually does. So if you look at, and I'm going to, for a second, go to this next page here, next slide. If you look at how these different courts are divided up for the U.S. Court of Appeals, all right, so as you would guess, we are in the 7th Court of Appeals, right? And as a general rule, actually, we kind of go back and forth whether the courts are more liberal or conservative. However, for example, we go out to 9th, which covers I'm not sure why it covers so many more states. I'm sure the population's factored in, but I'm a little surprised it covers that large of an area. But it is considered probably the most liberal court, most liberal appellate court in the land, in the U.S. Okay, so you have that, and then in Texas is part of the, as you can see here, the 5th court, right? 5th Circuit, I should say. So what happens here? You tend to have a lot more conservative judges, and so what you'll find out is, when people want to bring federal cases to, they eventually, their goal is to get to the Supreme Court or make a big deal about it. They will file, if it's a federal offense or a federal matter, they will intentionally try to wait until something happens in a state that agrees with the side that they want. Okay, so you'll find this happens a lot, especially here more recently with more liberal viewpoints on things. They will intentionally wait or try to file in all these states in this light green color here, especially in California, but they will file in those states so that it will be heard by a court that is more liberal and leans towards the decision they want. Same thing can be done on the conservative side. It tends to be done a lot more in the opposite way, but on the conservative side, if you wanted to, start things in Texas, for example, which is more likely to get a decision that you would want, okay, if you have the same political viewpoint or ideology. So I think that was pretty clear. And then, so once again, if you appeal here, since it's similar to this intermediate appellate court at state level, federal level, this U.S. Court of Appeals, if the decision doesn't, if you feel like it is unsatisfactory and doesn't really approach or answer questions as far as constitutional rights, then you can appeal to the to the U.S. Supreme Court. Now, one thing the U.S. Supreme Court can do, this is for all their cases, they can decide what they want to hear or what they want to look at. They really don't see or hear that many cases in comparison to all these other, trial courts or even lower level appellate courts. The U.S. Supreme Court looks at it, the information from the different cases that are, appealed to them in essence, say, okay, does this apply? How does this apply to a constitution? Does it apply to any civil rights, for example? And then they will decide whether they're going to hear it or not. That's essentially all it is. And then once they've made a decision, there is no further, there's no other court to go to, right? So that should make enough sense. If you have any questions, like I said, you can ask on Monday, or at least when we come back, right? So either way, this part really isn't that big of a deal. Understand case citation. Just understand that whoever is first is the one bringing the trial or the case together. So if it's a trial case or trial court, the first will typically not be an individual. It will typically be a state or an entity like that, maybe even the U.S. The country or the people is typically how it's viewed. In some states, instead of writing the state of Colorado, for example, they write out the people. And then you'll have to look out later in the citations where it says what state that is represented. But it will either say the people or the state to begin with on trial courts. And when it comes to appellate courts, it will, whoever is the one filing the appeal is who you will see first. That's why in this one, Garner versus Tennessee, it was an appeal, hence why it has Garner v. versus Tennessee, right? So it will, and like I said, if you need to find any of those, you can use LexisNexis, you can use Westlaw, Justify, OYEZ, however they want to pronounce that. Those are some places you can look. But as far as appellate court differences, the appellant, as you can read here, the appellant is the one who files an appeal. So say at the trial court, I don't get the decision I am looking for, and I have good reason to appeal. If I file paperwork to appeal to the appellate court, I am the appellant, right? And if you were the one on the original case, if you were the one who I was, let's just say I charged you with, well, I'll put it this way, you charged me as a police officer and as a state, in essence, you charged me with murder, right? But then, and the verdict is that I'm guilty. However, a lot of it is circumstantial evidence, or I feel like the evidence that was collected against my rights. Say there was no, say my Fourth Amendment there was a Fourth Amendment violation, search and seizure. You did not have a warrant at the time you came to my house, or you searched me in a way that was it was not incident to arrest. Or say you had me sit in a house, and I came to my house, you had me sit on a couch, and since you can check the area in my immediate vicinity, you check that, but then you had me move to another place in the house and check me again, basically using me as a way to get to search different areas. That would be illegal, and if you would have found incriminating evidence, it should have been thrown out if you used those methods. Okay, so that should be pretty self-explanatory. And these are the options you have for your appellate court rulings. So this is the higher court, the appellate court viewing, and it doesn't matter whether it be intermediate or state Supreme Court or even U.S. Supreme Court. These are what you would look at for your decisions. So reverse, as you can read here, it basically says it nullifies the lower court's decision, says, oh, that decision was wrong. This is what we believe. Okay, that's it. There is no hey, try again. It's simply that court, that lower court, was interpreting the law incorrectly, or it lacked some other type of evidence or element necessary for the verdict that the original trial court gave. So nullifies the lower court decisions, and this is something we can always discuss later. With a reversal, just because, say, if I have a case, like I said, I'm the one who appealed to if I'm the appellant, I appealed to the appellate court, and they said, okay, well, we'll nullify, we will reverse the decision and nullify that guilty. Okay, that's fine. But they didn't necessarily say they would let me out of, at that time, I may be in prison or in jail, probably in prison at some point. That doesn't necessarily mean I get out of prison yet. Okay, there are other steps to it, but that's just a reverse. Okay, it also depends on what other charges there were, other things like that. Okay, vacate. That simply means same thing as reverse, except, okay, now, and once again, as the person who was originally convicted of the crime, with reversal, I didn't necessarily get freedom immediately, but now with a vacate, they're vacating the charges against me, saying, okay, not only are we reversing that, but there are really no grounds to charge you with that, so you are free to go. Okay. And remand is basically sending the case back down to the lower court. So if the trial court, okay, they hear the case, they look at all the evidence, jury or judge, depending on how it was looked at, makes a decision, an appeal is made, the appellate court rules or looks at the information. That's all an appellate court does, is rule the important part. They don't they don't review the entire case again. They just look at it based on what the appeal was made on. What grounds was the appeal made on? That's all they look at. So what you'll see is the remand. Like I said, that appellate court will actually send it back to the trial court and say, okay, you need to look at this again, and you need to make a better, more consistent decision with your verdict. Okay, so that's pretty self-explanatory. And affirm is simply agreeing with the lower court's decision. Okay, that's pretty self-explanatory too. They affirm, they agree with it, and if I want to appeal to a higher court, I can. It doesn't mean the higher court will have to hear it. Okay. An opinion, these are things I'm not going to go into great detail about because it doesn't impact us a whole lot. But if you're reading a court case or a case briefing, this is kind of what it is. The opinion, and this is all through appellate courts, right? So it's not trial court, it's only through appellate courts you'll see opinions and dissent. So the opinion of that is, what was the rationale, or what was the reasoning behind the court's decision? So if it's 3 judges, which is typically how it works, 3 judges look at unless it's a Supreme Court, but 3 judges will look at, say, a state appellate case, and they'll say, okay, well, 2 of the 3 agree that the lower court was correct, right? So they are the ones, whether one of them or both of them, will write an opinion, meaning why did the majority feel this way, or why did they make that decision, okay? And then on the other side, you have a dissent, and that's if it's a court where there's 3 judges, then one of them will write a dissent, whoever it was that disagreed with whatever the decision was. Or if it's a Supreme Court, they typically pick one person, but to represent those who disagreed with the majority. Sometimes you'll find multiple authors for the dissent also. But either way, it's like I said, the minority opinion that does not agree with the overall decision.